Welcome to The Explainer. Today, we're going to map out the entire journey of a criminal trial in Canada, all the way from the initial charge to the final verdict.
So have you ever really thought about what happens after someone gets charged with a crime here in Canada? The moment that happens, it kicks off this whole journey full of really crucial steps and safeguards. In this explainer, we're going to follow that exact path, from start to finish, and hopefully demystify the entire trial process.
Okay, so let's jump right in. The whole journey begins the second a charge is laid by police. And the seriousness of that charge, well, that basically determines everything that's going to follow. It's the first major fork in the road.
At its core, the system classifies offenses into two main categories. On one hand, you've got the less serious stuff, called summary conviction offenses. For those, there's a strict 12-month time limit to even lay a charge. On the other hand, you have the most serious crimes, think murder or robbery. Those are indictable offenses, and for them, there's no time limit at all.
Now, this is where you really start to see how high the stakes are. We're not just talking about ending up in a different courtroom. The potential penalties are worlds apart. A summary offense might top out at 2 years less a day in jail, but an indictable offense, that can carry a sentence of up to life in prison. A huge difference.
But here's a little twist. Most offenses are actually hybrid. This gives the Crown prosecutor a really critical choice to make, something called a Crown election. They'll look at things like the accused's criminal record and how much harm was caused, and then they decide whether to go down the less serious summary path or the more serious indictable one.
All right, next up is the first big hurdle for anyone accused of a crime: bail. This crucial stage isn't about guilt or innocence. It's simply about one thing: whether they'll be released back into the community while they await their trial.
And this quote really illustrates the core principle perfectly. Our system is built on the presumption of innocence, which is guaranteed by the Charter of Rights and Freedoms. That means the default position is always release. Keeping someone in custody before their trial is meant to be the exception, not the rule.
To make sure release conditions are fair, judges have to follow what's known as the ladder principle. They have to start on the ground floor with the least restrictive option, and they can only climb the ladder to stricter conditions if the Crown proves it's absolutely necessary.
So the judge has to start at the very bottom rung of this ladder, considering just a simple promise to appear first. It's only if the Crown can show that's not enough that the judge can climb to stricter conditions, like say a no-contact order, requiring a surety, or in some rare cases, a cash deposit.
So when can bail actually be denied? Only if the Crown can prove one of three very specific grounds: that keeping them in custody is necessary to make sure they show up for court, to protect the public, or to maintain confidence in the justice system itself. Once bail is all settled, the case starts moving towards trial. And for many of the more serious offenses, the accused has to make a critical choice that's going to shape their entire defense. Who will decide their fate?
For most serious indictable offenses, the accused has the right to choose their trier of fact. They can elect to be tried by a judge alone, who will decide everything, or by a judge and jury. In that case, 12 ordinary citizens decide guilt or innocence, while the judge basically manages the legal side of things. But for the most severe crimes, like murder, there is no choice. The law says that the trial must be held before a judge and a jury. It's not optional. Now, it's really important to know that the vast majority of criminal cases never actually make it to a full trial. They get resolved through plea negotiations between the Crown and defense, which are absolutely essential to keep the justice system from grinding to a halt.
But when a case does go to trial, what does that actually look like? Let's step inside the courtroom for a minute and see how this search for truth unfolds.
The process is very highly structured. It always begins with the Crown, or the prosecution, because they have the burden of proving the case. They present all of their evidence first.
So first, the Crown presents all of its witnesses and evidence. Then, the defense gets its turn to respond. Once all the evidence is in, both sides make their final pitch in closing arguments, and then the judge or jury leaves to deliberate and come to a verdict.
To find someone guilty, the judge or jury must be convinced of their guilt to an incredibly high standard, beyond a reasonable doubt. And this isn't some kind of imaginary doubt. It's a doubt that's based on reason and common sense after you've considered all the evidence.
And this quote just brilliantly illustrates how high that bar really is. Being probably guilty or even very likely guilty is simply not enough. If that jury or judge is left with any reasonable doubt, they must acquit.
Woven through this entire journey, from the charge all the way to the verdict, is the Canadian Charter of Rights and Freedoms. It acts as a powerful shield to ensure the whole process is fundamentally fair for every accused person.
Section 11D is the bedrock. It guarantees the presumption of innocence. You are not required to prove you are innocent. The Crown must prove you are guilty.
The Charter also protects against unreasonable delays. Section 11B ensures that a case can't just hang over someone's head forever because, well, a fair trial also has to be a timely one.
And that's not just a vague idea. In a landmark decision, the Supreme Court of Canada set hard deadlines. For cases in provincial court, for example, the presumptive ceiling is 18 months from the time the charge is laid to the end of the trial.
Ultimately, the entire trial process is this really delicate balance. It's a system designed not just to convict the guilty, but also to protect the innocent, and it forces us to constantly consider the true meaning of justice itself.